Welcome to this week's episode of On Record PR, where we talk about the insights and strategies that matter most to law firm leaders. If you are joining us as a regular listener, welcome back. If you are new to our show, I'm Jennifer Simpson Carr, the Vice President of Strategic Development at Furia Rubel Communications. And today I am joined by my colleague and our resident certified SHRM professional, Elizabeth Ogilvie. Hi, Elizabeth.
Hi, Jennifer.
Thank you for coming back on the show.
Happy to be here.
So we are recording this episode to release on Tuesday, May 27th, after the long holiday weekend. Today, Elizabeth and I are diving into a topic that's become even more urgent for law firms, and it is how to build inclusive, high-performing workplaces in the wake of shifting federal policies and the growing scrutiny around diversity initiatives. So you may have heard Elizabeth on a previous episode. She is our HR guru at Furia Rubel, and today she's going to help us learn about SHRM's newly introduced BEAM framework, that's BEAM, which was designed in response to recent executive orders and ongoing debates over DE&I. So we'll discuss what BEAM means, what it means for law firms, why they should know about it and be thinking about it, why it's time now to evolve inclusion programs to ensure that they're compliant and impactful. Before we dive in, I want to share two caveats. One, that we are having a conversation today and it is not legal advice. While Elizabeth remains a licensed attorney, she is joining us today just to talk from an HR perspective. And also that Furia Rubel Communications recommends that any DE&I audits, changes, or discussions be made in conjunction with your legal counsel so that these discussions are privileged. So with those two things out of the way, let's get into it. So let's start with, what is the SHRM BEAM framework and why should law firms be thinking about what BEAM means?
I just wanted to for anybody watching, I will be referring to my notes because this is not an analysis that I have come up with. This is a SHRM analysis, and I want to make sure that the queries that we're presenting for our audience are in fact correct. So if you see me look away, that's what's going on. So the BEAM framework was created kind of as an analytical tool to run your programs through. It consists of 5 questions that you should ask about each one of your programs, and it helps you judge what adjustments need to be made. I encourage this to be a conversation about adjustments, not eliminations. We've talked about this before. I'm encouraging everyone to use this time to strengthen your programs, not eliminate your programs. There's simple, subtle ways that we can adjust all of these really, really important HR programs that support your employees in a way that's compliant with the letter and spirit of the EOs, as well as the recent court decisions, which I'm going to touch on briefly.
And what does BEAM stand for?
BEAM stands for Belonging Enhanced by Access Through Merit.
Okay, and can you tell us more about what that means in application?
I can, but before we get there, I feel like we should take like a 1,000-foot view of what's going on right now.
Okay.
The first thing, and I've mentioned this before, is that Title VII is still in effect and nothing in the EOs has changed Title VII. What the EOs have done is given us guidance as to how employment laws and Title VII will be enforced by this administration. So it's a different perspective. We have not changed things. This is a change in how it's being enforced, which is why we encourage everyone to be conducting this analysis now. Second, there have been several court decisions that have changed the landscape. So I'm just going to briefly mention them. This is not a legal seminar, so I'm just going to run through them pretty quickly. One case is called Snyder. Snyder has given us an insight into what is a thing of value, and we can apply this in the employment context for law firms. Snyder was about bribery, but it defines things of value which adds something that could be a mentorship, an internship, participation in internal programs that are career development oriented. You can think about almost every single one of your human resources opportunities for your employees as a thing of value. So these things need to be open to all. Second, we have Mulrow. Employees, in this case, the court found, only need to prove some harm in employment discrimination. That's a very low bar. When you're looking at a program that might be picking winners or losers or playing favorites, that could harm somebody. And we are now seeing from the Supreme Court, that bar is quite low. The last thing I wanted to mention was Ames, which I believe we're still waiting for final decision on that. But Title VII applies to all groups, whether you're in the majority or whether you're in the minority. We do not differentiate when we're doing a Title VII analysis. So all of these three put together tell you that whether or not the administration had these executive orders, law firms were going to have to probably change some of their internal human resources programs anyway. So the train has left the station, is what I am trying to say, outside of what the administration is doing from an enforcement perspective.
Mm-hmm.
Does that make sense?
It does. And it's so timely because the events we attend, the virtual programs, the conversations that we're having, this is the on the top of the list of things that law firm leaders are thinking about. It is one of those issues that has been keeping many law firm leaders up at night. And we're receiving endless questions around how to approach their individual situations in light of executive orders. So yes, it makes sense and it is timely. You mentioned earlier that there are 5 questions in the BEAM framework.
Yes.
So how can law firm leaders use them to audit or improve their inclusion initiatives?
So the BEAM rubric focuses on merit-based inclusion, where your performance and skills and access to opportunities take priority over identity-based considerations, anything demographic, right? So what are the questions? The first question we ask you to consider are your internal programs, are those opportunities equally accessible regardless of sex, race, or other protected status? Now that seems pretty basic, but you need to make sure that your programs across your organization, across your law firm, are solely based, the participation is based on qualifications and a business purpose rather than demographic factors. So that's the top line. The next analysis is, are the criteria you are using for entry into any of these programs grounded in relevant skills and competencies? Also, critically important, you need to make sure that the objectives of your internal programs, those criteria have job-related qualifications. Third, do your eligibility requirements match your business needs? Is there a business purpose for your employee resource group, for example? Your eligibility requirements really should serve a legitimate business purpose. The stronger that business purpose is, the more unassailable your program is, whether it's an ERG or a parent networking group or anything of that nature. Fourth, are all your programs communicated about across your organization clearly and to everyone? And anecdotally, I really want to make this point. There are certain very large organizations that don't announce, for instance, job postings to the entire organization. They'll just send it to the San Diego office or the Tucson office. SHRM suggests that these opportunities be broadcast across your organization, and that means across geographies. Are these opportunities being communicated through newsletters, company meetings, widely enough that nobody has to search. It's open, it's not a secret. Those opportunities are there for anyone to participate in if they meet the relevant qualifications and criteria. The last one, do your programs and initiatives provide valuable business-aligned learning opportunities for all employees that are eligible? That kind of wraps up everything we've already talked about. You need to make sure that all of your programs are broad-based and merit-based. So if you take those 5 questions and you apply them to your internal programs, you'll be able to see pretty quickly which ones pass this kind of analysis and which ones need adjustment.
So as I was reading through the BEAM materials to get myself up to speed for just generally, but also for this conversation, one thing that I noticed is that one of BEAM's core principles is merit as the primary lens. So my question for you is, what does this mean in practice for law firm recruitment, promotion, and talent retention, which is a big consideration for law firms right now as they are looking to retain and attract really great talent?
Yeah. Well, I'll give you SHRM's definition first. So SHRM defines using merit as the primary lens, talent identification focused on measurable skills and performance, using skills-based assessments to eliminate bias and ensure that decisions reflect true potential. I think that's beautiful. It's perfect. And that is how we should be approaching our hiring and talent decisions. That's why another reason I think that this is actually a good thing that's happening, even though it's causing mass disruption. I think this is going to strengthen your programs for the long haul in a way that is more permanent and accessible to all. So for hiring, I'm a huge supporter of inclusive hiring, and it's something that I think law firms are lagging at. For example, if law firms could eliminate some of the more subjective criteria they use when they're winnowing down applicants that come in, they would have a fairer process. I mean, for example, what does it mean if someone is on law review? How can we be sure that even getting on law review was an unbiased process? So in that way, by eliminating subjective things, the name of the school, whether the school is a top tier, and focus on things like, is this applicant a Rule 9 attorney? Did this person actually practice law in federal court? I did. And it gave me a boost in my skill set. That to me is a concrete skill. And it's not subjective. It is actual proven work that was done. And further to that point, broadening the pipeline altogether is a great practice to make your hiring practice more equitable. And I think that, within our agency, we've been talking a lot about AI, and I think that a lot of our clients are talking about AI as well. If we implement AI correctly, it can be another tool in our toolkit to make hiring and promotions more equitable. We can use automated tracking systems for applications. We can use something like an Otter AI technology when we're interviewing candidates, even in a group setting, so that we can develop transcripts that strip out names and any demographic information. Those AI transcripts can then go to a hiring committee that isn't seeing where this person went to school, their gender, any of those other what part of the country they're from. They're only reading the substantive answers and determining based on those discussions, does this person have the skills and competencies I'm looking for?
So could you talk for a minute about bias in AI? And I know it's a little bit sidetracked from the core of the BEAM discussion, but I know that there has been a lot of conversation around bias in the technology. And just can you touch on that for a minute and how law firms can consider the technology they're using?
So in HR, we talk about validation a lot. So are your numbers valid? Are your processes valid? All it means is we've gone and we've tested and tested and tested and tested and tested. You need to make sure any tool you're using has been validated so that you know the results you're getting are accurate. And you would do that with any tool that you would use. Same thing with AI. I know it's new, I know it's fancy and exciting, but AI makes mistakes. So, and we won't get into it today, there are ways to validate and test your AI systems. But by adding AI into some of these hiring processes, especially processes that involve lots of interviews, a lot of different touch points throughout your organization, having something that does it in a blind way, so you are really just focused on those skills and competencies, is really going to get you further on the path to having the most equitable and strongest inclusive workforce.
So I want to go back to the executive orders. You and I talked about those earlier this year. You did an incredible job breaking down during a very heightened state of panic, I think, in the legal community, what they truly meant. So with the recent executive orders restricting certain diversity, equity, and inclusion practices, and kind of in turn creating new legal risks around the traditional DEI efforts we've seen at law firms, how can law firms stay compliant without abandoning meaningful inclusion efforts that they have spent time, resources, and energy putting into place?
I think of this as not eliminating, but adding,
Okay.
right? Amending, not ending. There are certain talent and hiring practices that we're all aware of in the legal community that we don't talk about, and they're not great because they are biased. And what we're asking is take a neutral look, go through this analysis, and make this a mindset shift away from picking winners and losers or playing favorites to make it more equal. I like to think of it as skills over subjectivity, which is my phrase. But if you approach everything with skills rather than subjectivity, you're in a safe space. That is the zone where all of our HR should really be functioning in.
So, how do you see all of this big picture reshaping traditional approaches to diversity, equity, and inclusion in the workplace generally?
Things are going to change, and I don't think that's a bad thing. I think that, I hope in the future that we're going to be doing some podcasts on ERGs, but there are ways that we can make these safe spaces for everybody, right? Everybody needs to play by the same playbook. Everybody has to follow the same rules of the road. And that has not historically been the case, whether everybody wants to admit that or not.
So, you've mentioned ERGs a few times. I know what they are because of you. For those listeners who may not know that acronym, what does that stand for, and generally, what does it mean?
ERGs are employee resource groups. You may know them as special interest groups. You may just know it as moms get coffee together online, or dads supporting dads, or there are so many fun and interesting employee resource groups, and they provide a huge benefit. They give employees a sense of belonging, especially during a stressful time like parenthood. They are a lifeline sometimes, just to have that other person that you work with away from work talking about some of the things that are maybe stressing you out and helping you cope better. And you know what? That makes you a better employee. These are the kinds of benefits that we want to save and enhance. And using the BEAM framework, we can do that in a safe way that does not attract negative attention and makes everything more fair and equitable for all.
So we will drop in the show notes a number of links, including the conversation that you and I had earlier this year about the executive orders and the impact on diversity, equity, and inclusion efforts at law firms. and also some resources from SHRM and the BEAM framework, more explainers if our listeners, need that information. We are recording an episode for next week on ERGs. So for those listeners interested, stay tuned. Elizabeth, I know you have a lot to share around that and that you're passionate about that topic and enhancing those opportunities for employees. Thank you so much for joining me. I learn so much from you, and the lens through which you view the critical issues of the day for law firms is invaluable to the agency. I've been learning a lot from everything that you've been sharing, and I'm really grateful for it. So thank you to our listeners as well. We appreciate you tuning in. If you have enjoyed this episode or any of our episodes, please consider leaving a review on iTunes, sharing the episodes with your friends or colleagues. We really appreciate your feedback on topics. So please continue to send those to us at podcast@onrecordpr.com. And we will see you next week to talk about employee resource groups.
Thank you, Jennifer.
Thanks, Elizabeth.
This episode is brought to you by Furia Rubel Communications, a public relations and marketing agency serving law firms and businesses worldwide. With an expert team positioned throughout the U.S. and supported by an international faculty, Furia Rubel enhances our clients' brands through integrated communications by providing expert guidance in crisis management and high-profile litigation, protecting brand and reputation, and supporting internal marketing teams. To learn more, visit furiarubel.com. On Record PR is produced by Jennifer Simpson Carr and Matt Henderson, with support from the team at Furia Rubel Communications. This episode is edited by Isabel Horan and Christian Yamula. Visit www.onrecordpr.com for resources and more information.